Every day in the USA, people find themselves in court.
All right, we are next taking up the case of People of the State of Michigan versus James Burke. This is file number 24-13941 FH. Hey. All right, folks. As we continue with today's docket, I've called the case. Appearances from counsel.
Good morning, Your Honor. Corey Wiggins on behalf of the people. And I'm Jeff Harrison. I'm here on behalf of Mr. Burke. He's joined me at the table.
Thank you. Mr. Burke is currently held in pretrial confinement, and the court also recognizes Ms. Lindsay Simmons, the agent from the Michigan Department of Corrections, who has prepared today's pre-sentence investigation report. I'll note that I have received and gone over the pre-sentence investigation report. If I had any need for correction. All right, I didn't see any need for correction. I'll also note that I've received and read the CFJ 104 update. All right, Mr. Wiggins, any objections, corrections, or amendments that we think we need to make in the PSI?
Your Honor, I'm satisfied with this context.
Same question to the defense, Mr. Harrison.
I have no proposed changes to the scoring or whatever.
All right, thank you. At this time, it's appropriate, based upon this being a Victims' Rights Act case, to entertain a statement from the victim. Counsel approached me at the sidebar, let me know that there has been an issue, medical issue for the actual victim in the case, and that a family member will speak. With that, as it's been agreed to by the parties. And I understand that there may be a couple other family members or sisters you may all approach. We're going to use this podium right here, if you so choose. It's up to you. All right. Hold on, I see a solidarity here. So, all right, thank you. Ma'am, why don't you go ahead and state for me your first and last name?
Good morning, Your Honor. My name is Kim Beats. I'm one of Robert Russell's 4 daughters.
Could you spell your last name for me?
Dietz.
All right. And ma'am, your name?
Sandra Harwood.
And common spelling?
Pardon me?
Common spelling, Harwood.
Yes.
And your name?
Sue Coon, Coon.
Yep. And your name, sir?
Robert.
Nice to see you again, Rob. I recall.
Okay, Jason.
Thank you. All right. Yes, ma'am.
Ready then?
Yes, ma'am.
Okay, in the late morning of September 9th, 2024, I went to town to do a quick errand. I told my adult son, who has special needs and is still dependent on me, that I would be back within an hour. I was on my way home when I turned onto West 55 and saw a black car coming from the other direction. It appeared to be traveling at a high rate of speed. I saw it flying around the curve, going to beat hell. And then when it got closer, the driver looked right at me and crossed the center line. I felt he had aimed directly at me. He seemed to be trying to hit me head on. I really thought he was trying to kill me. I was able to jerk the wheel to the left. He hit my rear passenger side, and then the next thing I knew, I was rolling and glass was breaking all around me. I later found out from the state police that I had actually rolled 2.5 times and was airborne at one point. Later find out that this person walked away from the scene, that this may have been intentional, and that there were many other people terrorized by this person earlier in the day. It was unbelievable to me. By coincidence, the EMS workers were already at the scene and happened to witness the accident. They were able to get me out of the vehicle and transport me to the emergency room. Once there, I was able to make a call to one of my daughters and let her know what was happening and have her call the neighbors to make sure my son was taken care of so that he would not worry. While in the ER, many tests were completed that showed I had no internal bleeding or head trauma. However, x-rays showed that I had 3 compression fractures of my spine. I was pretty banged up with scrapes and bruises and in a lot of pain, but able to go home and be in the care of my daughters. In the early weeks, the pain was so bad that I couldn't think straight. I could barely get out of the chair to go to the bathroom. I had to use a bedside urinal, and even the lightest weight cup in the house was painful to lift to get a drink of water. I couldn't change my clothes without help. After some time had passed, I attempted to do some of my normal activities and chores, only to be in so much pain that I had no choice but to make another trip to the ER. I had to spend the night in the ER so an MRI could be performed. This revealed that there were actually 7 different fractures in my spine and ribs. I have had to make several follow-up doctor's appointments, a consult with a neurosurgeon, and some physical therapy. Again, I needed my daughters to stay with me and help with daily tasks and organize these appointments. The injuries from this accident have forced me to sleep upright in the chair for almost 3 months. I have difficulty standing long enough to make meals. Riding in the car can be difficult, and my movements have been restricted. I was unable to drive for quite some time, not only because my car was totaled, but because my pain and spasms prevented me from doing so safely. I've always been an active person who loves to be outside. I enjoy mowing the lawn, fixing cars, tinkering around my property on my tractor, cutting wood and removing snow. My son and I visit my wife's grave at the cemetery nearly every day. This has all come to an abrupt halt because of this accident. Normal life has been turned upside down. The stress of it all has really taken a toll on me and my family, especially considering my girls live 2 hours or more away. I've had to rely on my daughters for care, groceries, meals, taking me to appointments, errands, cleaning, purchasing a new car for me, and many other tasks that I've been unable to do. I've had to deal with countless phone calls from insurance companies, letters, bills, doctor's appointments, and the like. I would like the court to know that the actions of the defendant have really impacted me a lot. Just everyday things I normally enjoy, I can't even do. What he did that day is completely ridiculous and just so senseless. Only a person with evil in their soul chooses to do something like that to others. I don't care if he was on something or not, because when you're under the influence, the real person comes out. His recklessness could have killed somebody, and we're all lucky it didn't. I hope that he gets punished to the fullest extent of the law. He has no right to be behind the wheel of a car ever again. He was out to kill somebody that day, and he's liable to try it again. I realize that whatever punishment the court decides to hand down will never erase the physical injuries, emotional trauma, and property damage this person has caused everyone involved, especially my family. I hope that his punishment will prevent him from hurting others. I hope the defendant does some self-reflection to better himself, to get the help he clearly needs, and tries to do some good with his life.
Thank you, ma'am.
His life.
Thank you, ma'am.
Thank you.
Folks. You may return to your seat. Mr. Harrison, allocution, sir.
Indeed, Your Honor. I appreciate the sentiments expressed by Mr. Rossell. And I think the word that he used, time of the incident, says a lot. Frankly, what he said was, all of it is just so senseless. And that's the dilemma that we have before us this morning. We know that Mr. Burke was heavily intoxicated. We know that he has little to no recollection of the order of events or the sequence of occurrences or any of that went down that day. We know in speaking to him now that he has trouble believing that this was all him. This was stuff that he did. This was stuff that in which he was involved, because it seems so senseless. It seems such a wasteful turn of events to a gentleman that, well, he struggled or has struggled with substance abuse, mostly alcoholism, throughout his entire adult life, was making strides and had made strides. This is a man who, in no small measure, due to his own foibles, was forced to recreate himself a couple of different times in a couple of different ways. He's enjoyed great success in a couple of different fields because his overall greatest asset is his intellect. But even his intellect, even as smart, as well-learned, well-spoken, well-educated as he is, simply could not overcome the effect that alcohol has had on his mind, body, and soul throughout his life. This is difficult for me to say. It's difficult for him to hear, because he and I have been able to discuss his situation, the profundity of it in particular, over the course of the last couple of months. And I had a conversation with him the last time we talked, and I said, what should I say? What should I say to the judge? What could I possibly give as an explanation here that would carry the day? And we couldn't come up with anything, because, again, what we're dealing with here is something that, as aptly described by the victim himself, is just so senseless. It doesn't really hold any logical examination. You can't say this is the cause of this and this was the cause of that, and there was a chain of events here that snowballed out of control. So I don't offer an explanation. I think that's one of the obligations I have as a defense lawyer in most occasions, is to give some semblance as to why did this happen? What was the thing that precipitated the event that X, Y, Z? And obviously this case is not going to lend itself to such a linear examination. I will say this, and I'm satisfied that Mr. Burke did not have any evil intention that day. I'm satisfied that what happened that day is something we may never fully be able to grasp, understand, and certainly explain. I can tell you he's exhibited a great deal of remorse for the people he put in harm's way, particularly Mr. Rossell that day. And we both expressed a lot of gratitude for two things. One, that Mr. Rossell survived the accident. If you had seen the events, if you had seen, even as described in the police report, the horrific nature of the damage to Mr. Rossell's vehicle, the relative lack of injury to Mr. Burke is also something that we can look at in a positive light. Now, where is the silver lining here? Well, the silver lining is this: he's had an opportunity yet again to examine. He possesses the wherewithal and the intellect to examine what happened and what, not only his level of responsibility for what happened that day, but what can he do to pay back, to make good, to provide a penance for the damage and the emotional damage that he caused that day. And he's resolved to deal yet again with his issues with alcohol. He's had an opportunity to stabilize his mental health in the ensuing weeks. Now, I don't think I need to go too far off the beaten path to explain why someone with a mental health crisis ought not to consume alcohol. But again, that's a cautionary tale, perhaps reserved simply as a warning for the future. I do think that this is one of the cases where there's not really a statute, nor is there really a quote sentence guideline that can really explain or succinctly wrap up or tie up and put everything in its place here and leave a neat conveyance from one stage to the next. I think this case is exhibited by the victim's statement, and certainly to Mr. Burke as well. The ramifications of this are going to be eternal for all intent and purpose. Now, I think it's easy to say the fullest extent of the law, say what is the most time I could prescribe for him to serve as a sanction for this incident. I think it's also easier to say, easy for me to say, look, the guy was polite and attentive in the whole process here. His criminal record, while it is somewhat lengthy, is not terribly extensive, at least in terms of drugs and alcohol and that sort of thing. And although it's not a defense to his actions at all, if he had not been either mentally ill, suffering a mental health crisis, or imbibing alcohol that day, none of us would be here. This is the type of case that I think puts the onus on the court to fashion a sanction that probably at the end of the day isn't going to satisfy fully any of the people involved in the case. So I appreciate that dilemma that the court faces in this regard. I trust the court's discretion based on Mr. Russell's comments, based on my comments, based on, frankly, whatever the prosecutor is going to say, that you will achieve that balance. If there was a way, I could say that he's already served a great deal of time here in the county. I would like to see him serve the rest of that sentence within the county. I would do so. I also realize the court has discretion to go well above that. And I trust that discretion in this case. Thank you.
Thank you. Mr. Harrison, I'm sorry, Mr. Wiggins, the floor is yours.
I guess I'd like to know where the defendant was polite and attentive. Was it when he brake checked the semi? Was it when he confronted the couple on the expressway? Was it when he sideswiped Mr. Schaefer and kept going? Or was it when he hit Mr. Russell and just about killed him and fled on foot? I guess I'd like to know where that comes into play. Now, I will admit, after he was apprehended and charged and through the plea process, he has been polite. As far as a mental health crisis, I haven't heard anything to that. What I do know, at least from the police report, is it appeared the defendant was going through some marital problems. He drank himself to .255 and damn near killed several people while he doing it. The defendant's criminal history shows that he has a very violent past. When I look at CFJ 284, page 7, his adult history 109, he was convicted of assault and battery. 2 of 9, he was convicted of an attempted unarmed robbery, which might not be an assault crime, but it's still a crime against a person. 3 of 9, assault and battery. 6 of 9, battery or domestic violence. 7 of 9, domestic violence. Now, he has our case that he's here to be sentenced for today. He also has a case pending down in Osceola County for his actions down there the same day down along the expressway. Your Honor, I think this is a case in which the guidelines don't accurately take into account what all transpired here. I do realize his guidelines are 12 to 24, and I realize the recommendation, at least in the severe charge from the Department of Corrections, is 24 to 60 months with credit for 126 days. But when the court takes into account the fact the injury sustained by Mr. Russell, the impact on him, the impact on his family, for quite frankly, probably the rest of his life. Your Honor, I don't believe the guidelines take that into account. Before I forget, Your Honor, there is a restitution request, $1,000 to Scott Schaefer. That's the count 4. And also in that same account, there's a restitution request of $2,688.37 to Latitude Subrogation. Your Honor, as I said, I realize that the guidelines in this case are 24 to 60 months. I'm going to ask the court to exceed those guidelines. Thank you.
That second amount again of restitution that you referenced, Mr. Wiggins?
$2,688.37.
$2,688.37.
Correct.
And that was the Latitude sub.
Correct.
All right, thank you. All right, Mr. Burke. A lot has been said. I know you've been sitting there very quietly, and I appreciate that. I also want to note that this was a no contest plea, which the law allows a defendant to enter. And again, as I mentioned, when there's a no contest plea, it can it can be based upon a couple of reasons. One of those is a potential civil liability, of course, but the other is inability to recall, either due to extreme intoxication or controlled substances or whatever. So I want you to know, I'm also stating that out loud for everyone else, because some people like to say they want to hear something, but I understand that this is a legal proceeding. Is there anything you wish to add at this time, sir, per se? And you may remain seated, I understand, because you're in restraints. Yes, sir?
I'd like to apologize to everybody. Not me. It was me. It wasn't. I'm sorry to everybody involved.
Mr. Burke, first I'm going to begin by saying to everyone here who's on behalf of the victim, an apology may not smooth out everything, but when there is a no contest plea, 9 times out of 10, the attorney says, don't say anything. Mr. Burke did extend an apology, because also if they don't extend one, everyone that gets upset and says, well, they never apologize. So the step that he did might, I hope, add just a slight twinge of satisfaction. Maybe that's the right word. The next thing I'm going to turn to is, by the way, I can guess what I'm going to say, and I've got a lot of notes. It always goes to the trash because everybody changes what I want to say. The next thing I'm going to address to Mr. Burke here is, there was a comment made, and I respect it extensively because in many instances, it's true. Sometimes the alcohol reveals the true person. I can tell you that in my experiences, there are some where it doesn't. It changes a person. I say that, and I often, it's not at all about me, but it's to take what I've learned in my life and apply it on the bench. My dad was an alcoholic, he was a great guy, but when he was under the influence, the other guy came out, and we would often refer to him by his middle name instead of his first name. And that's okay. So I'm going to accept what you said there. That it's not you when you aren't drinking. The challenge is that you consume often. And apparently when you do, it's binge type drinking. Here, the blood alcohol level is 0.255 by the time you got tested by the department or the law enforcement officers. Mr. Harrison mentioned that there was a mental health crisis. I will state on behalf, to respect that, the defendant did have 2 mental health hospitalizations within the year. prior to this all occurring. So I do acknowledge that there was some degree of mental health crisis. With all that being said, while I acknowledge some of the things in favor of the defendant, I guess is the right way to say it, there are a lot of other things that I need to talk about. The law again requires, and this Michigan Supreme Court requires, that the court provide extensive discussion to establish its reasonableness and proportionality for the sentence. It's only up until the time the court gets to provide comments at sentencing that I actually get to apply much of my own judicial discretion, which is of course limited within the law. The guidelines do not, or are not mandatory. The Supreme Court has been very clear in its rulings that while the legislature can put some limits, they can't substitute for the discretion of the judge, which is why, in part, the guidelines are not mandatory. All right, so I have to jump around a little bit, and I apologize, and so please bear with me as I've got notes scribbled everywhere. Take a first look here at the events that day. The events that day are well detailed here in the report on challenge today demonstrate that the defendant was on a binge and was driving, was reckless, was putting people in danger all over the Wexford and Osceola County area. No, if anyone's ever looking at this for appeal, is going to say that I'm sentencing for something in Osceola County, but I'm just saying that this was an event or series of events that covered Osceola and Wexford County, and specifically I'm looking at the facts here that apply in Wexford County. Bottles out of a car, reckless driving on 131, and much more. But really, we don't have to look much further than the events out there on M55 near 115, near the Pines and near the hotel. Your blood alcohol level was unacceptable. Whatever made you think even for a moment you should be behind the wheel, I don't know. Or maybe there's a level of you being a functional alcoholic for being able to drive with a .255 and having so many alcohol related issues in your life. That must have been it. I can only imagine the fear of somebody's driving in a car and turns around and sees this car heading at them. There's nothing they can do. You cannot account for that in the guidelines. I can't imagine the pain. Well, I could probably imagine a little bit, but I'm going to sound really stupid. I've had a handful of broken ribs, but I've never had this kind of pain. I can tell you broken ribs hurt, and you can't calculate the pain when you've got broken bones and you've got the injuries that we have here in this particular case. You also can't calculate the impact on someone's life. And the legislature knows they can't. That's why the guidelines are they aren't mandatory, and they're just the best guess that they can do to give us something. When you can't calculate an active person who no longer can do all those activities. I can tell you when I've had injuries from being a runner, a biker, if I can't run or bike, I am not happy. And here, this is well beyond anything I've ever suffered. Can't put into points on a guideline the inability of a person who's very active not being able to do those things, not being able to go to the cemetery to see his wife's grave, as I've read in the report, as I read and heard throughout this today. You can't put any points on that. In the fact that you got up, walked away, left the scene, and then went and got more alcohol. You set the vehicle into a ditch upside down. for brevity's sake, I'm just gonna say to anybody who's ever having to look at this case in the future, just read CFJ 284, pages 3, 4, 5, and up to the top of 6 to understand how horrific this event was for other people. And then when you got caught by police after walking away, getting more booze, walking around, being found, your comment was, for the record, I'm just gonna read it. I fucked up, I crashed my car, dude. No, you nearly killed somebody. Looking at your criminal history, which began in 1996. That was an assault and battery. You made it, looks like, about 4 months into your next charge, which you committed while on probation. That was an unarmed robbery for which you had probation violations. And you ended up getting sent to prison due to those violations. It looks like after you were off of, no, while you were on probation, you picked up a second case, which was another assault and battery. And you picked up the same case, another case on that same day while on probation. That was an MIP. Then you made it a very, you made it, no, you had another case going on at the same time also, but I should take note that that was dismissed. Entry 6 of 9. You had just been off of probation for about 9 months, and you picked up a domestic violence, and you got a 9-year gap, and you did well apparently for 9 years, or at least didn't get caught. You picked up another domestic related offense. Your probation was revoked. Then you had a gap in time where you picked up this charge down in Osceola County. Do we know what happened to that yet? It says in my report that it's still pending.
That's still pending, Your Honor. He was arraigned on those charges, and his case was bound over last week to circuit.
And then you picked up this case. Let's talk a little bit about, sometimes what I have to do is I need to explain my sentence to everybody because nothing I'm going to say is going to undo the pain, is going to undo the act. I want everyone to understand who's listening and reviewing this case, what the limitations are placed upon the court by the plea and by the legislature. This was a habitual offender second. That second was dismissed as part of the pretrial agreement. That has 2 impacts. Number 1, it reduces the minimum range of the guidelines. So these guidelines here that we've talked about in this case are 12 to 24. That guideline range before the reduction of the habitual offender second only reduced at 6 months. The most in that guideline range, even without the deal, it would have been only 12 to 30. It does reduce the maximum from 7.5 years down to 5 years. That's pretty much about it. So you've got to keep that in mind when you look at the guidelines and the sentence the court is able to give based upon the law, both that handed by the legislature and that handed by the Supreme Court. The pretrial agreement really didn't do a whole lot for the defendant other than bring the max down 2.5 years and bringing the recommended minimum guideline range from 12 to 30 to 12 to 24. As a judge is supposed to balance and look at each side. And I thought this a lot lately. It's so easy to pass judgment based upon our perspectives. And that's why I began today by recognizing for Mr. Burke that he has had some mental health issues. And that maybe, just maybe, this person that we see when he's consuming, hopefully isn't the same Don when he's not consuming. We also don't know why there have been some mental health issues. We don't get to talk too much about that here as to what happened in Don's past that has brought him to where he's at now. So for the record, and for Mr. Burke, I believe it's appropriate, and I do, again, recognize that there is a person under the alcoholism. Maybe it's not this, maybe it is the same person, but at least he doesn't seem to come out when alcohol isn't there. But at the same time, the law says that when the court doesn't find the guidelines to be adequately scored, they don't adequately account for the facts, I can exceed the guidelines. And I'm going to do so today. Because again, and I want some legislator or appellate court tell me, how do I put a point? How do I put a sentence on that pain? Not like we get to score for, well, they broke 2 ribs versus 1. He broke 6 vertebrae versus 1. You can't put a point on that. What I see here is beyond what can be scored in the guidelines, as again, I find that they do not adequately account for the pain, the suffering, the level of intoxication, the spreading of this behavior around the county, to where he crashed and nearly killed somebody, got out of the car and went and bought more booze. I can't put a point on that. So the court sentences the defendant as follows. Oh, by the way, and again, I acknowledge the probation issues and the parole issues in the past. So this is clearly not going to be a supervisable probation jail sentence. The court sentences the defendant today to $168 state minimum fee for the felony, $2 $50 state minimum fees for the 2 misdemeanors, a $130 crime victims' right fund fee. The court will not assess any court costs, and the court must assess a minimum fee or fine of $1,000 for the operating while intoxicated causing serious injuries. Other than that, the court does not assess any additional fines because I want whatever money's available to help go back and pay the restitution. The court also will not assess any attorney fees at this time for the same reason. Court assesses $1,000 restitution payable to Mr. Scott Schaefer. The court assesses in restitution $2,688.37 payable to Latitude Subrogation. Was there any other? I know there's this request for an insurance claim. Is that where are we at between the parties on that? I don't know if that's.
I believe. Aaron, the only restitution request I have is from Mr. Schaefer and that Latitude.
Okay. I will leave restitution open for 30 days should the prosecution determine that additional restitution should be sought. All right, one moment. Ms. Simmons, I've noted that on your CFJ 145, list of counts or charges in a different order than you do on SIR 88-1 when you list conviction 1 of 3 for the felony. I don't know which one I should file, assess the counts for. Madam Clerk, any opinion there? Which one do I list in order?
I have them as count 3, 4, and 6.
All right.
In our system.
All right. Well, that's okay. That's all right. For count 3 is the failure to stop at a personal injury accident. In that particular case, the maximum punishment is up to 1 year. Therefore, the court sentences the defendant to 365 days with 126 days of credit. Pursuant to the law, I must state that the court finds there are reasonable grounds to exceed the statutory presumption of fines and costs only. I believe that probation is not appropriate based upon the probation violation history I've already talked about. And I also find that there are, again, extensive reasonable grounds, even for that failure to stop at the injury accident. Therefore, that sentence is fair and appropriate. As to the leaving the scene of an accident of attended vehicle, that's count 4, Madam Clerk. There, the maximum punishment is up to 90 days. Again, the court assesses a 90-day jail sentence with 126 days of credit. Again, the court finds that there are reasonable grounds, as I've stated well today on the record, to exceed the presumption as set by the legislature. Now we come to count 6, which is the operating while intoxicated causing serious injury. Again, I have stated extensively today the reasons that this court finds that the guidelines are inadequate, and the court therefore sentences the defendant, and to the level that we might have to, or anyone argues, substantial compelling application. There are substantial compelling reasons to find that the guidelines are inadequate and to support the sentence and to support exceeding the guidelines. Therefore, the defendant is sentenced to a prison term of 36 to 60 months. And that is also within the 2/3 rule, and the court grants 126 days of credit. That does exceed the guidelines by a year. And again, I reassert the statements and findings I made earlier. Ms. Simmons, have I missed anything?
I don't believe so, Your Honor. No.
Mr. Wiggins? All right, and Mr. Burke. Mr. Harrison's going to bring to you 2 copies of one document. You're going to place your name or initials on the first copy, about halfway down on the right-hand side. This document tells you that you have the right to appeal the conviction and sentence in your case. While that is typically done by filing a claim of right to appeal if you are found guilty at a trial, based upon the plea, any appeal must be done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to consider appointing an attorney to assist you, you may complete the bottom half of the document and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. And I note that this guideline range was 12 to 24, and even at a trial, at most it could have been a 12 to 30. However, if there was actually a finding of guilt for the assault with a dangerous weapon, that actually could have been increased even further, because it would have moved from a PRV. No, it still would have been a PRVC, but still, based upon the totality of all these facts, I find that that's a fair and appropriate sentence. Anything else, Ms. Simmons?
No, Your Honor. Thank you.
Anything else, Mr. Wiggins?
No, Your Honor, thank you.
Anything else, Mr. Harrison?
Nothing for you, Your Honor. Thank you.
Mr. Burke, I know that, and I can see it on your face, and I'm stating this for the record. You are still a young man, right? Let me take a look here. I can't remember. Yeah, 45. You can change your life and finish well. My dad at one time was my best non-paying client. And I can tell you, he spent the last 10 to 15 years out of trouble at church beside us every Sunday and finished well. You can finish well. You're only 45. He died at 74. You've got a lot of life to live. While you're there, take advantage of those opportunities to better yourself. Because I'm hoping today, I'm taking you at your word, that the Don Burke that is there without alcohol is not the same man. We are adjourned.